the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-5079. Abdulsalam Ali Abdul-Rahman Al-Hela, Detainee Camp Delta, also known as Abdulsalam Ali Al-Hela, and Abdul Wahab Ali Abdul-Rahman Al-Hela, as next friend of Abdulsalam Ali Abdul-Rahman Al-Hela, appellants, versus Joseph R. Biden Jr., President of the United States, et al. Mr. Zients for the appellants, Ms. Harrington for the appellees.
Good morning, counsel. Just a reminder that because we're in public session today in a case involving classified material, we'll refrain from referring to any classified material during the course of the arguments this morning. Mr. Zients, please proceed when you're ready.
Thank you very much, Your Honor. Good morning, and may it please the court. On behalf of Petitioner Abdulsalam Al-Hela. Since this court granted en banc review, the government has abandoned its argument that the Due Process Clause has no application at Guantanamo Bay. It has also made a factual determination that continued detention of Mr. Al-Hela is not necessary to protect against a significant threat to the security of the United States. Despite these developments, one thing has stayed the same. Mr. Al-Hela remains in detention, where he has been for 19 years without charge or trial. And the government takes the position that even though continued detention is not necessary for the interests of national security, it can keep detaining Mr. Al-Hela until the end of the conflict, which can seemingly never end. In every practice.
Is that the nature of the determination, or was the determination that we need not detain him at Guantanamo? We don't know whether the conditions involve a detention elsewhere, or do we?
Your Honor, the Periodic Review Board was acting under a delegation by executive order to determine whether continued detention is necessary for the security to prevent against a significant security threat to the United States. The bottom line answer that the PRB gave for Mr. Al-Hela is that it is not necessary. Now, in reaching that final determination, the PRB considered that based on what it viewed as Mr. Al-Hela's past activities, there was some risk, which the PRB concluded could be mitigated with adequate protections and assurances in terms of a program that he could be released into. And all Mr. Al-Hela is asking for is what this court has called conditional release. So, I think the bottom line of the Periodic Review Board is that the government has determined that his continued detention is not necessary. There is a way to adequately protect the security of the United States without detaining Mr. Al-Hela. So, in our view, as a matter of due process, you just said all he's asking for is conditional release, if I heard you correctly, and your habeas petition, obviously, you're on this because it was written in 2005, a very long time ago, so quite understandable. Can you explain to me exactly what you mean, or your client means, what he wants from a habeas corpus order? Sure. I think our habeas petition, I believe, asks for release. So I think certainly we're not saying that we don't want an order that just says release, but what we said before the panel, I think this is in a footnote in the last page of our brief to the panel, is that Mr. Al-Hela would be very happy with an order that is what this court calls conditional release, which is an order that Mr. Al-Hela's continued detention is unlawful. The government is under an obligation to release him, but the government will have the time to identify a place for him to go to line up security, proper security assurances, and I think that would solve, what the
how is that different from what we already have, given the PRB decision?
Your Honor, I think it's a good question, and I'd like to be really precise about what the PRB does and does not decide. What the Periodic Review Board was delegated to do, was assigned by executive order to do, was to make a factual determination. Is Mr. Al-Hela's continued detention necessary to protect against a significant threat to the security of the United States? It says no. The PRB was not delegated any authority to do anything about that determination, and we know that. I'd refer to the brief that was put in by Mr. Al-Bahani, who was cleared for release 10 years ago under a very similar
determination. It was slightly before the PRB, but it's essentially the same determination. Continued detention is not necessary for the security of the United States. He's been in detention for 10 years. So all we know right now is that, the government has made a factual determination that Mr. Al-Hela's continued detention is not necessary, but for whatever reason, he remains in detention.
So in other words, are you suggesting that there is no case or controversy before us as to whether your client should remain in detention, but simply a question of the conditions for release? And under the regulation, the government is obligated, or the Secretary of Defense and the Secretary of State are obligated to move efficiently in arranging for that.
Your Honor, right now, I don't think as a matter of internal executive branch practice or regulation, there is any need for the executive branch to do anything. What they have done is the Periodic Review Board has made a factual determination that Mr. Al-Hela's continued detention is not necessary.
I understand, but the point is there is a regulation that says when that determination has been made, then the Secretaries of Defense and State are to move expeditiously to release the detainee. So I don't see your brief to address that, but I understand from what you're saying today in terms of conditional release that you don't view any dispute with the government on that issue.
Your Honor, I think we do have a case or controversy that the way I would describe the current dispute with the government is this. The government has determined that Mr. Al-Hela's continued detention is necessary, but it is very clear in its brief, it believes that it continues to have the legal authority to detain Mr. Al-Hela till the end of this conflict. And who knows how long the government will consider this conflict to remain ongoing. So under those circumstances, we have a very real dispute. Mr. Al-Hela continues to be deprived of his liberty. We don't know what the government is doing.
Can I ask the question this way? So as Judge Rogers was referring to, the executive order itself says that if a final determination is made, then the secretaries shall be responsible for ensuring that vigorous efforts are undertaken to identify a suitable transfer location. So the executive order imposes an obligation to undertake vigorous efforts. And so I'm trying to understand what the potential daylight is between where you think things are and where the government thinks things are, if in fact vigorous efforts are being undertaken. You've said at the outset that you don't have an issue with the conditions, as I understand it. You don't have an issue with the conditions that the government has described as we understand them from the order of the PRB. So is all we're talking about whether the government is in fact adhering to what the regulation says the government needs to do in the event that the finding that's been made has been made?
Your Honor, we really don't have a way of knowing, I think, what the government is doing, has been doing. We know that it is very possible, that after someone has been cleared based on a determination that they no longer pose a security threat to the United States, Mr. Al-Bahani continues to be detained for 10 years. Nothing is stopping Mr. Al-Hela from being detained for another 10 years.
What if this court rules that your client should be released? The same problem that faces the government when somebody has been cleared for release, and that is finding a country that will take him. There's no difference.
Your Honor, Mr. Al-Hela represented to the court in his brief before the panel, and I don't think anything has changed, that in his view, in order requiring his release by this court will help in efforts to find a place for him to be resettled. And I think beyond that, a court order means something, and I think the government.
Well, so does the executive decision saying that he should be released. That means something too. I don't see what the difference is.
Well,
if this were in the United States, he could walk out of the prison gates. That would be fine. But he's on an island, and he has to be released someplace other than Cuba. So the question is
going back to your basic argument here, is it your position that somehow the principles of due process require more than what the executive order does? Is that your argument?
Your Honor, I do think that because I think the executive order doesn't accomplish release or doesn't.
Well, in what way? Why don't you just say a little more about that? Let's assume you're right that due process principles apply here, given in the context of what Hamdi said about it. But in what respects precisely would principles of due process that you envision here apply a more rigorous standard than the one set forth in the executive order?
Your Honor,
to be able to get any relief here, it seems to me you've got to be right about that.
Sure. Your Honor, I view it as a distinction more between right and remedy. The due process right we're claiming, one of the due process rights that we're claiming, is that Mr. Al-Hela is being detained past the original purpose of his detention. And there's a long line of precedent saying when the original basis for non-criminal detention is over, is satisfied, is no longer necessary for that purpose. Due process, the government cannot continue depriving someone of their liberty. That's the principle. I think the question in a habeas case is what is the remedy? And we know that habeas is flexible. And this is why I think the court has recognized this principle of conditional release. As Judge Randolph says, this is on an island, and there needs to be somewhere for Mr. Al-Hela to go. So I do think it is not that if the government were to act on its determination and release Mr. Al-Hela, that would, I think, would make everyone happy. But we know for a fact that that for 10 years Mr. Al-Bahani was cleared for release, and I think there's been reporting that for at least some portion of that time, perhaps the government was not acting vigorously, as Judge Srinivasan put it, to find a place for him to be released. And I think that is where in Article 3 court comes in.
Mr. Zients, we don't have any reason to think that we're there now. This administration has not made the same representations that it is uninterested in making those vigorous efforts. And I guess another way of framing the question is, if we believe we have a very powerful obligation of constitutional avoidance, and if what's established is that your client has a habeas remedy, and if one of the things that the habeas remedy might afford him is a non-constitutional basis for the same relief. In other words, the government is saying, yeah, we've made this determination, but we have legal authority to continue to detain your client for the duration of the conflict. And if we were to disagree with that and say, well, under the circumstances when you, the executive, have determined that you don't have a security reason to keep him, maybe you don't have authority under the AUMF. If that were an available ground under habeas, we wouldn't have to reach your substantive due process claim. Why isn't that the prudent course that constitutional avoidance counsels?
Your Honor, we'd be very happy with that result, relying on the AUMF. Before the panel, we argued essentially this principle under both grounds, as both a statutory and constitutional matter, that there is a limit to this detention. So we're very conscious that in granting en banc review, we've been directed to brief issues of due process. We certainly do. We certainly reiterate our argument that there is a way to avoid that constitutional question, and ruled that the AUMF has not authorized continued detention in this circumstance.
I guess I'm getting a little confused. I had thought your habeas case and the point of pre this PRB decision in, I guess, August it was, all right, prior to that what Mr. Al-Hela wanted to show is that he was not, he's not an enemy combatant, he's not a threat at all, he's not properly held under the law of war, and it's not, you have the point about timing, that you think the threat, if there was a threat, it is dissipated. But I had thought, and it's one of the reasons there was so much concern about redactions, hearsay, and these types of things, that in fact his baseline position was, I don't qualify for law of war detention, full stop. And one, have you abandoned that? And if not, Two, is it your position that if you got all the process you wanted, and if that were the result from a district court and a habeas petition were to agree with Mr. Al-Hela and say law of war detention not allowed for this person, full stop, would they be able to still say we can only release you with security conditions? Would it change the nature of the release? Or is all that over now? We're only talking about conditional release.
Sure, Your Honor. Well, first of all, we're not abandoning the underlying challenge to the procedures that led to the district court's determination of substantial support in the basis for Mr. Al-Hela's detainability. I think we started with.
Then why are you agreeing to conditional release? That's a condition when the conditions are consistent with someone for whom security protections are needed. This is where I'm very confused about what's going on.
Sure. Your Honor, in some ways, I think it's a path to a narrower resolution that with the executive branch having determined that his continued detention is not necessary.
Yeah, but if it's going to end up lasting 10 years, like Mr. Al-Bahani, then that would be plenty of time to have your primary contentions resolved and addressed. So I'm just confused about your position, and it's your position, your clients, and that's the most important thing. I just want to understand where we are now. Whether we really have much of a due process question left.
Right, Your Honor, I think we do. Fundamentally, Mr. Al-Hela's position is that he's been detained for 19 years. The executive branch has determined that that's not necessary, and there should be an order based on that, that his continued detention is not consistent with due process. Or, I think I think the court could also rule, as Judge Pillard suggested, as a matter of constitutional avoidance, that in these circumstances, continued detention is not authorized by statute. So, I think the way we're approaching this, in some ways, comes from a very practical concern of how do we get Mr. Al-Hela back and reunited with his family, which is what the PRB found is really all he wants. I do think, though, we are very much insisting on the position and taking the position that there were incredibly flawed procedures that led to Mr. Al-Hela's the determination that the district court made that he was properly detainable. I'm not sure, even if there is a determination by the court ultimately that Mr. Al-Hela, there is no basis for detention. I'm not sure what the government's position would be on whether they can still insist on some security assurances.
Well, I'm not asking you to tell me what their position is. That's why I was trying to ask you what your position is. And you said conditional release is your position either way.
Certainly, I think because we have this, what I view as a narrow basis under substantive process to claim conditional release, I suppose if there were ultimately a new round of process to remedy the deficiencies that we found and there were determination, then I think perhaps there could be a court order that says just simple release. But I think the reality is, I think a court order of conditional release that put the government under some obligation to find a way to get Mr. Al-Hela out of there, to tell the court, to explain to the court if he is not released promptly based on that, why. I think that will help Mr. Al-Hela more quickly than to go back, possibly years of further process, ultimately to perhaps get a less qualified order of release. So I'm viewing this very practically from Mr. Al-Hela's standpoint.
Isn't it another question here then? If you do not think that any dispute between you and the government as to your client's current eligibility for release exists, and the only question is, can the government find a country that would take your client under the conditions that the federal government determines are necessary for the security of the United States, then just assume for purpose of my question all that is true, then what purpose would the determination that you want serve? Would it be as a matter of prudence to control our court in the sense that after your case, another case may come up. And while we vacated the panel decision, another panel could come along and rule either that due process does not apply at Guantanamo, or it does apply. And presumably a petition for rehearing would be filed by someone. And we'd be right back where we started, and we'd have to reconvene in bank once again. So to the extent we have this rule that 3-judge panels are bound by the decision of an in-bank court, does that serve any purpose, even given the principle of constitutional avoidance?
Judge Rogers, I think it does serve a purpose, and I think we have seen that there has been some back and forth within the panel's opinions, and I do think we're 13 years after Boumediene. I think broadly speaking, it would be incredibly valuable for the en banc court to settle the question of the availability of due process rights at Guantanamo. But I think if I hear your question correctly, I think the question sort of goes to mootness. Is there really a continuing case or controversy over this issue? And I really think that there is. What the government says in its brief is that what happens now is entirely a matter of executive branch discretion. They think they have the constitutional statutory authority to continue detaining Mr. Al-Hela for the duration of this conflict, irrespective of a factual determination that they have made within the executive branch that his continued detention is not necessary for security reasons. So I think we have a really clear legal case or controversy. We say that his continued detention is unlawful. They say it is lawful.
So to the extent that the board decision only became final 2 months ago, does that change anything? I know you filed your petition in 2005, but the process has delayed so that now we're still considering that petition. But in the meantime, the government, as a matter of discretion, has, through this board decision that now has become final, and the government's brief nowhere suggests that it's backing off or that the Secretary of Defense has raised any objection to that decision. So it has become final, at least under the executive orders and the regulations promulgated by the department.
Your Honor, I again I look at this from the perspective of my client, who for 19 years has been in detention without charge or trial. The date of the final determination of the Periodic Review Board was the 8th of June. So that was about 3.5, almost 4 months ago. And to be honest, I think if that doesn't sound like a long time to be deprived of liberty, it's only because of how long Mr. Al-Hela has been deprived of his liberty already, and it will take time for this court to issue a decision. If there were any kind of remand, that would take time. So time keeps just passing on by, and Mr. Al-Hela remains in detention. So I think.
So,
Mr. Zients, I have just a practical question here that occurs to me as I've been listening to this for 25 minutes now. So the PRB decision was issued obviously after the district court acted. And given that, and given that we have an obligation to avoid deciding the constitutional question if we can, and given also that your answer to many of our questions about what the government is planning to do, you don't know the answer to, isn't Judge Lamberth in a far better position than we are to get to the bottom of this, to find out whether there really is any longer a dispute between the petitioner and the government?
Judge Tatel, I have two responses to that. One is to go back to the answer I gave to Judge Rogers. Mr. Al-Hela has been detained for 19 years. This is going on, and I think there is a really powerful liberty interest in getting a resolution sooner rather than later. That was essentially what the Supreme Court said in Boumediene. I think there was a criticism from the dissent. Shouldn't we have let sent this back, let the detention, the DTA review procedures play out a bit more and see how that develops. And the Supreme Court said, this detention has been going on a very long time, and there's a really profound interest in moving these cases along.
Mr.
That was
Zients,
2008.
But for you,
I guess part
but
of-
related to my question is, it seems, I hear what you're saying, but you still need to demonstrate to this court that there's something about the due process principles that you seek to have applied here that would give him something more than he's gotten either from the district court or under the executive order. And I haven't heard that yet.
Sure. Our view of the due process clause is that when the government, at least when the government has made a determination that the original basis for Mr. Al-Hela's detention no longer holds, is no longer necessary, he is entitled to release. I think we now have a fight about remedy. And I think the question is the remedy that we're contemplating any different from what the government is already doing? And the honest question to that is,
isn't it possible that he would be entitled to exactly the same relief under the suspension clause? I mean, what's the difference? Yeah.
I think that the Supreme Court's holding in Boumediene is that there's an opportunity, there's an entitlement to meaningful review of detention. I don't think the suspension clause provides substantive law for whether or not detention is lawful or not. Our view here is, the AUMF, of course, imposes limits on that, and our view is that the due process clause does as well. And if I could just go back very quickly.
Mr. Zients, if I could just ask a question to clarify that. I guess you have to have an account of, it seems, from the questions that are being asked. I mean, if this court were to determine that Mr. Al-Hela's due process rights were violated and we were to rule that way, how would that change the executive branch's discretion about whether to release him or not? I mean, aren't we in the same place? And I think that that's really the question. How does a judicial decision about due process change the executive's practical authority to keep him in detention?
Your Honor, I think what it would change is that a court order is serious business. So a court order that says the government is required to release him, and we're not going to force the government to do that right now while it is looking for a place that has the adequate assurances, et cetera. But I think as part of the habeas court's inherent authority under such an order, the government would probably, I think, could fairly be required to report on what it's doing.
It really is the effect of the court order that you're talking about, because just to get back to the standard that the executive is imposing on itself, and by virtue of the final determination of the PRB, the executive order says that the executive has imposed an obligation on itself to undertake vigorous efforts to secure release under the parameters set out in the final determination. You don't think that when the executive determines that someone should be transferred, that somehow miraculously they're supposed to do it right away? I mean, obviously some practical things have to happen in order to effectuate that determination. And what the executive has said in the order is that it will undertake vigorous efforts. It sounds like from your answers to these questions, you're on board with that. That's satisfying to you. What the delta that you see is that you have a court that's looking to make sure that the executive, in fact, is undertaking the vigorous efforts. Because if those vigorous efforts are being undertaken, it seems like that's exactly what you want.
I think that's right. And I think that would be the result of the court order that we're looking for. There would be some way to know what the executive is doing. I think to Judge Tatel's question, which I think was suggesting a remand to find out what the government is really doing. I suppose we could, again, this is something that I won't put words in the government's mouth, but I would think based on their view that this is all discretionary, they view themselves as having no obligation to tell anyone, including Mr. Al-Hela or the district court, what it is doing, to carry out this sort of internal executive order obligation, which, as far as the executive is concerned, is totally internal to it. So from our perspective, yes, I think a court order absolutely makes a difference here.
Let me ask, and Mr. Zients, isn't there a factual basis in the record to make that representation? In other words, I had understood that there's at least one other detainee who is in a similar position who has been held after PRB determination for a decade. So there's some reason to believe that the government is not necessarily interpreting its obligation to move expeditiously consistent with what you think the due process clause requires.
Judge Jackson, I think that's exactly right. We know that Mr. Al-Bahani has been quote unquote cleared for release, but has been detained for 10 years. And I think his brief actually explains he was even told that that the government was getting ready to release him and decided not to for reasons that don't even have to do with him. So this is, whether or not the new administration is acting in a different way from the old administration, the reality is, the executive branch has a lot of different priorities. What we have here is someone who's been detained for 19 years that the government says it does not have a security need to continue detaining. All we're really asking for is a court order that would allow Mr. Millett to not have to rely on an executive order that the government views as totally discretionary.
So to be
Let me
crystal
ask
clear,
you, go ahead, Judge Millett. I was going to follow up on your questions, but you're probably better suited to do that.
no,
I just
sorry,
I just want to ask, you keep relying on Bahani. Why has he not been relocated?
Your Honor, I don't know the answer to that question.
The answer is very important, because on the one hand, your claim is that the government is being lackadaisical and not acting vigorously. But if in fact no country will take him, then that's another story entirely. No matter how vigorously the government is acting, no country will take him. And you don't know, right?
Your Honor, I don't have any way to know the answer to that. I mean, there was a period of time when the president of the United States said publicly there should just not be releases. So this was at a time when Mr. Al-Bahani had been cleared for release, but the president said there shouldn't be any more releases. So we do have some knowledge that there have been periods of time when perhaps the government was not moving vigorously to find a place to relocate. But the reality is we don't know, and I just don't think that can be an answer that divests the habeas court of authority to order release when it exceeds its lawfulness.
Let me ask you on the current. So I gather, I mean, there are sort of two different due process issues that we've been talking about here, and really the panel decision and your initial brief were before the periodic review board kind of changed the landscape on the substantive ground of detention. And your focus then was on the procedural steps that had been taken by the district court. And I think earlier in the argument today, you said that the procedures were incredibly deficient. And I know there's some limitations given by the classified nature of the record, but what is wrong with the basis that Judge Griffith used for saying, no, actually, these procedures gave a meaningful opportunity and or meet the Matthews approach? What shortfall really on this record that bears on Mr. Al-Hela? I mean, even if you could identify which of the claims you think is the strongest, because now with some familiarity with the record, I could use guidance.
Sure. So I think the procedural deficiencies sort of all work together. For example, this is a case that was fundamentally about credibility, the reliability of certain sources, an incredible amount of not just hearsay, multi-layered, often anonymous hearsay. And I think it works together with the ex parte, the ex parte information that the district court considered without disclosing to either Mr. Al-Hela or his cleared counsel. And I think what the district court says in its unclassified portions of the opinion are that the use of that was principally for these reliability issues. So essentially, you have Mr. Al-Hela being detained on a low standard of proof, the kind that is used in slip and fall cases. And it was principally based on—
I'm not sure that issue was preserved to the panel, the burden, the standard of proof.
Your Honor, I think our view is that it all sort of, again, works together, and of course, I think the court can decide if that is before it or not. But even holding that aside on the standard of proof, you do have what this court has said in other contexts. Singletary versus Riley, Judge Brown's decision for the court about the limits that the due process clause imposes on the use of hearsay in a parole revocation setting where someone's liberty someone is being deprived of their liberty. There comes to a point with multi-layered and anonymous hearsay where fundamentally there's just no way to know credibility, and you add upon that the reliance on ex parte information to uphold the detainability of Mr. Al-Hela.
My understanding of our case law is that unreliable hearsay cannot be used in this context. That hearsay it's admissible because these are bench proceedings, but that the district judges very much do have an obligation in relying on hearsay to really probe reliability questions and not to rely on it if there's a genuine reliability problem. And do you disagree that that's the framework that applies currently under our precedent?
I agree that is the framework under your precedent, and it's actually I think it's one good reason why due process adds something here beyond certainly what this court has viewed as the baseline of the suspension clause. What the Supreme Court said in Hamdi, it applied the Matthews v. Eldridge balancing analysis under very different conditions, battlefield capture, detention not nearly as long, and it applied that. And even on hearsay, it says that hearsay may need to be used as the most reliable evidence that's available. So because the district court viewed due process as inapplicable, it did not consider, for example, is there something better? Is there better evidence that may be available? So in Hamdi, where there was an active shooting war happening in Afghanistan, it would have been an incredible burden on the executive to require someone who was involved in the capture of Yasser Hamdi, who saw that he was holding an AK-47, to come to Virginia and to testify. What the district court never did was apply the Matthews v. Eldridge framework under due process and ask the question, is there anything practical preventing, for example, the author of an intelligence report that contains multi-layered hearsay in it, who may not be on a battlefield, it may be in Langley, Virginia, and it wouldn't prevent, wouldn't cause any harm to the government, to drive to Constitution Avenue and explain, be cross-examined. What did you mean? Did you consider this person reliable? And
it's your position that you've made the record in this case that could have made a difference. The difference between the paper record and the declarant or the recorder of the information that the paper record reflects being present. That is not just a more protective measure that could have been taken, but that it's a more protective measure that in the particular context of this case made a material difference. The lack of it, of the live witness, actually makes a material difference. You think you've made, and I realize we have constraints of classification, but just, you think you have made that record.
Your Honor, we think we've made that record. I think an answer to that would have to come in a classified submission, but just stepping back and just looking at this holistically. This case itself is fundamentally a case about credibility and nuance. If you look at the government's chief allegations against Mr. Al-Hela, he was a government official in Yemen. The district court found that at least part of what he was doing what he was alleged to have done by the government was part of his official government responsibilities, as part of his role in this program for the deportation of the so-called foreign Arabs who were residing in Yemen. He had to meet with extremists and have relationships with extremists. So we're in this very nuanced question of what exactly was the nature of those relationships. Was he doing everything he did, in furtherance of a government role where the government of Yemen was trying to get extremists out of the country? Or as the government alleged, was he going beyond that? Was he abusing his authority? And was he doing something more? So I think in a case like this, we're just inherently in a zone of credibility, reliability. This is not, was Yasser Hamdi carrying an AK-47? Did he receive Taliban training? We're talking about much more fine-grained and nuanced determinations to be made, and on a record that as we've said, sort of replete with this multi-layered anonymous hearsay. And on top of that, Mr. Al-Hela, even his cleared counsel, has never been given the opportunity to look at significant information that the district court relied on to resolve those very questions.
Let me make sure.
I'd like to ask a question about that goes to kind of the legal status of your client presently. And so let's suppose your client had been detained and brought to Guantanamo, and the government brought him there thinking that he was an enemy combatant, but realized that he was really actually not, and that he was an aid worker. And so he's at Guantanamo, but they have determined that he really wasn't an enemy combatant ever. And so they say they have no need to release him, to detain him. Would your client, if those were the facts, would your client be in the same have the same legal status? If those were the facts, then the legal status that your client would have if we were to find that there was a due process violation and in effect vacate the executive determination that that he was an enemy combatant. What's the daylight, or what's the difference between those two scenarios?
Sure. Well, I think if as a matter of our procedural due process argument, there was a determination that he was not adequately found determined to be an enemy combatant under the statute. It would be, I think it would be the same as the tourist or the aid worker, that the government has someone that has never had any legal authority to hold. I think on our substantive due process argument, where
so if that's the case, then if your client were the aid worker and there'd never been an enemy combatant finding, would the government be allowed to release him only if they got security assurances, or would the government just have to release him whether they could get those assurances or not?
I think the government would have to release him. That there would still be the question of finding somewhere for him to go. This was essentially the situation with the Uyghurs when the government determined that they were not being properly held as enemy combatants, and there was some effort to find a place because they couldn't be sent back to China where they would be tortured. So I think there would be some work for the government to do, but I do agree that there wouldn't be a basis for the order of release to include security assurances.
Let me tell you something. I'm familiar with the Uyghur situation you mentioned, and the government acted vigorously for a long period of time, had great difficulty, and a lot of this information is classified, but they had great difficulty in relocating them, but they never gave up. There were diplomatic maneuvers and other contacts with other countries, on and on and on. And so it kind of gives the lie to the idea that unless you have a court order, the government's not going to act vigorously. It acted vigorously in the Uygher case for 2 years.
Well, I guess what I'm getting at with my question, counsel, is if we hear your constitutional claim and either we or the district court on remand agree that there was a due process violation, and in effect, the government's kind of enemy combatant designation is wiped away, does that put your client does that kind of give the government less legal basis to take action that would inhibit your client's release? Yes
Right.
or no?
I think yes, Judge Wilkins, it would, but I also don't view it as a sort of binary one or the other. I think at this time, Mr. Al-Hela is entitled. You should receive a court order requiring his release, at least under those conditions, because, going back and having a remand and sorting out these procedural deficiencies. Again, after 19 years, he wants to go home and, he wants to be reunited with his family. And so I do think it would get him something, to have to vacate the determination that he is, properly detainable. But it's just thinking that this very practically from my client's perspective, he wants to be released sooner rather than later.
Would it affect his detention? I'm sorry, go ahead, Judge Randolph.
I guess I had a question. I mean, if we were to find that due process applied in this case, in what way, if at all, do you think the standards that were applied here are different from Hamdi? Do you think that the standards here are less than what was afforded in Hamdi? I mean, I understand that your position is the balancing should come out in a different way for Mr. Al-Hela, but the government suggests in their brief that you do not contest that the Hamdi standards were not met for due process, as a general matter, in terms of the procedures that were employed.
Sure, I think we do think that the court would have to do the Matthews v. Eldridge balancing analysis now, as Judge Traxler said in Almari, his controlling opinion. Hamdi wasn't setting a one-size-fits-all rule of due process, and it very much depends on the circumstances. But I realize that is not direct answer to your question. I think the direct answer to your question is that even as a matter of Hamdi on hearsay, what Hamdi says. Just a sentence on hearsay. It wasn't purporting, to set, the standard forever in all cases. It says hearsay may need to be. I won't try to quote it from memory exactly, but what Hamdi says is that hearsay may need to be used as the most reliable evidence that is available. In our view here is there's been no showing that there is not more reliable, more available evidence that could have been used. For example, the person possibly sitting in Langley, Virginia, who wrote this, who wrote one of these intelligence reports and could be confronted on what it really means. Can you clear it up? Did you think this person was telling the truth? Was there a transcription error? So I think there's a lot, even within the framework of Hamdi itself. Mr. Al-Hela, I think, got less than that. And frankly, I realize that we're not here talking about the suspension clause. If you look at Boumediene and what Boumediene says about the deficiencies in the DTA process and why habeas is necessary, it talks about a rule under the CSRTs where hearsay is always admissible. That is now the rule under this circuit's precedent. So I think it really is under both Hamdi and Boumediene. Mr. Al-Hela has received very little process. He has not received, what even Hamdi suggests should be the rule for hearsay. But we also think after 19 years, for someone who is not detained on any kind of battlefield, the Matthews v. Eldridge, balancing analysis really comes out quite differently for Mr. Al-Hela.
Can I ask a practical question? If while you're awaiting the government's vigorous efforts, your client wanted to go forward with habeas to clear his name, to vindicate his claim that he, in fact, should never have been categorized as an enemy combatant. He was just a good government employee. And say he were to win that habeas. But nonetheless, efforts still need to be made for his release. Would his conditions in which he's detained at Guantanamo change while he awaits that process? Were the Uyghurs kept in less constrictive conditions? Is there anything that would change for him?
Your Honor, I'm not sure I know the answer to that question. I can try on rebuttal to make sure I have an answer if one is available.
You're not claiming that as a liberty interest that's still at stake?
No, we're not talking about the conditions of confinement, Your Honor.
Okay, let me make sure my colleagues don't have any additional questions for you at this time. Mr. Zients, we'll give you a little bit of time for rebuttal.
Thank you, Your Honor.
If they don't. Okay, thank you, Mr. Zients. We'll hear from the government now. Ms. Harrington.
Thank you, Your Honor. May it please the court, Sarah Harrington for the federal appellees. I'd like to make clear from the start, if I can, that the United States believes that the Constitution requires robust protections for Guantanamo detainees who bring habeas claims. Those habeas proceedings must provide detainees with a meaningful opportunity to contest the lawfulness of their detention, including by rebutting the factual basis for that detention and by presenting exculpatory evidence. In these types of proceedings, the suspension clause requires district courts to employ substantive and procedural safeguards that are at least as protective as those the due process clause would impose if it applied here. And that is what happened in this case. Because the due process clause would not provide any greater protection than the suspension clause already provides, the court should decline to decide whether it does in fact apply here. The court should—
in order to reach that conclusion, I think some of the questions that we've been exploring is what is required by due process for a person in Al-Hela's circumstances. And
Yes, Judge.
until we decide that, how can we decide, much less assume, that he would be entitled to nothing more than he would be entitled to under the suspension clause? That seems to be an assumption in your brief that the two are equivalent. And where has the Supreme Court said that in the manner that you're saying it in your brief?
So, Judge Rogers, in Boumediene, Justice Kennedy, writing for the court, assumed that the procedures that were in place in the CSRT process satisfied due process.
Assumed.
Right, exactly. Assumed not dissenting, but he nevertheless held that the suspension clause required significantly greater protections in habeas corpus proceedings.
So the question is open.
The question is open, yes. But the other piece of the puzzle then, of course, is Hamdi, where the Supreme Court opined on what the due process clause would require for the detention of a US citizen held in the United States as an enemy combatant. Surely any procedures that meet those requirements that are set out in Hamdi are sufficient when you're talking about a non-citizen who is held outside the United States.
Actually, the Hamdi plurality was careful to say that the details would need to be worked out by the courts below.
That's exactly right, Judge Rogers.
So it didn't say this is all that's required under any circumstances. And of course, Hamdi even suggested that after 10 years, maybe the executive branch's determination that someone was an enemy combatant who required continuous detention needed to be re-examined. And you don't deny that circumstances have changed dramatically since then.
Circumstances have changed, but the conflict with Al-Qaeda and its associated forces is ongoing. Mr. Al-Hela doesn't make any suggestion to the contrary.
Now, in fairness to him, he was writing his brief before the president made his most recent statements.
He did, but the president and the generals, when they testified before Congress earlier this week, have made clear that the conflict with Al-Qaeda and its associated forces continues.
Of course, you agree that the president under our constitutional system is the commander-in-chief.
Yes, that's right, Judge Rogers. And if I could take the procedural part of your earlier question, if you look, over the last 13 years since Boumediene, this court and the DC District Court have put in place very robust procedural protections that govern these habeas proceedings. And it's not just the minimum that was set out in Hamdi, it's quite a bit more than that. And if I can just sort of tick off some of the things that govern these proceedings, these are set out in the case management order as it was amended.
Well, that's my real point, isn't it? That at least those procedures have assumed, even without deciding whether due process applies, that more was required. And certainly the district court here did more.
Right, that the suspension clause itself required more. And the reason for that, and this is explained in Boumediene, is that here you have judicial review of an executive determination that detention is appropriate. It's not as if you have one court reviewing a different neutral court that made a determination about detention. And so you need more robust procedures in reviewing the basis for the detention. And you have those here. So first, what the district court does in a habeas case in this context is it makes a de novo determination of whether there is a valid basis for detaining the person. That's quite different from what you think of as a traditional habeas type of proceeding where you have a federal court reviewing a state court conviction where a great deal of deference is given to the fact finding. There's no deference at all that's given in this context to the government's determination that someone is an enemy combatant. Second, the government has to turn over all exculpatory evidence that's reasonably available to it. And we take that obligation seriously. We view that the definition of exculpatory evidence quite broadly. We turn over evidence that undermines our own claims with respect to inculpatory evidence. We turn over evidence that could undermine the reliability of our evidence, that could undermine the reliability of witnesses, including any evidence about the context in which various statements were made. We also
that all sounds good, but there's a big exception there, which is that the government can turn over exculpatory evidence, and it does, but at the same time, it in the same filing that's in camera and ex parte, it can give its own explanation about why the evidence isn't really all that exculpatory. And in some instances, that's classified and petitioner's counsel can't respond to that. Isn't that right?
I don't know if that's exactly right, Judge Wilkins. It is true that in the way that Matthews versus Eldridge would require it, if it applied, that the district court has procedures in place that balance both the government's interest in protecting sensitive national security information and the petitioner's, the detainee's interest in getting meaningful review of his detention. And it has resulted in these procedures that govern classified information. So I understand that Mr. Zients hasn't had access to the classified record, but his co-counsel from the habeas proceedings did have access to the classified record, and the judges on this court have access to the classified record. And so you can see what was turned over to the cleared counsel.
The cleared counsel does not have access to the top secret information that the district court sees only in camera. And is it your representation that there are not instances in this case and otherwise in which potentially exculpatory evidence is shown only in camera to the court, and the government makes the case, this appears exculpatory, but actually it isn't, and the district judge agrees, and that never gets seen even by cleared counsel? Does that happen or not? And has that happened in this case or not?
I don't believe it's happened in this case. What I know about what's happened with the exculpatory information in this case, or I'm sorry, the ex parte information, the district court relied on ex parte information in 4 instances, and only in each instance to make a credibility determination with respect to a source. 3 times finding the source credible and 1 time finding the source not credible. I can give you pages in the JA where you can look, it's redacted in the public version, but you can go and look at the classified version. It's pages 143, 155, and 190 for positive determinations of credibility, and then 156 to 157, footnote 11, for the negative determination of credibility.
What's the last page cite?
I'm sorry, it's 156 to 157, footnote 11.
Thank you.
So you can see how ex parte information was actually used in this case. Now, before there can be any introduction of ex parte evidence, there has to be a determination made that there isn't a way to share the information with Mr. Al-Hela's cleared counsel. And you can see in the ex parte materials, there is a robust back and forth between the government and the district court judge. Judge Lamberth did not go easy on the government counsel, nor should he have. We are not shirking from our responsibility to provide detainees with a robust opportunity to challenge their detention. But it is also just a fact of life that sometimes there is very sensitive national security information that if it were shared with cleared counsel, let alone with the detainee, it would reveal sources or methods of intelligence gathering or and things along those lines. And courts have held for decades that the government has a compelling interest in protecting that kind of information. Of course, it's not just our say-so that is superintended by the district court. We have to make a showing, we have to convince the district court. And again, the use of ex parte evidence in this case was quite limited.
Ms. Harrington, you said that the district court makes a de novo determination, unlike in a habeas circumstance where the court is reviewing a state court. There's no deference to the government's determination. How does that square with the presumption of reliability or presumption of regularity that is applied, which does defer to government documents, government witness statements, and the like? There is some deference built in.
So it's not deference as to the substance, Judge Pillard. It's not a presumption that the government documents are accurate. It's a presumption that they were correctly recorded, essentially. It's a rebuttable presumption. As I said, we have to turn over exculpatory evidence to the detainee. The detainee can ask for discovery. there's a robust exchange of information with the detainee, and even much more so with his cleared counsel. And so there's an opportunity for a detainee to contest whether in fact a government document is entitled to the presumption of regularity. And again, it's not a presumption of accuracy or truth, it's a presumption of regularity. It's unclear if that played, so first of all, I'd say I should have said at the start, we think Mr. Al-Hela has waived a right to challenge that aspect of the procedures because he didn't challenge that before the panel. But it's also unclear what role, if any, that played in these proceedings in this case.
Counsel, can I go back to the ex parte evidence challenge? You mentioned that it was limited, the court's reliance on it only 4 times. You give us the page numbers, but I'm just trying to understand whether or not that's consistent with what we and other courts have said about the Classified Information Procedures Act kind of process. Doesn't the government have to choose? There can be no reliance unless there is an adequate substitute given to defense counsel?
But I don't think, Judge Jackson, that there are any bright line rules like that. The district court has to make a decision before allowing ex parte evidence that the evidence is material and that access wouldn't be necessary. Access by the cleared counsel wouldn't be necessary to facilitate a meaningful review. Also has to look at whether there are less sensitive substitutes, alternatives that could be available. If a district court decides that it would be inappropriate to allow the submission of or reliance on a certain piece of ex parte evidence because it thinks you need to have you would need to reveal it for meaningful review, it can order the government to turn that information over. If the government is unwilling to do that, then the district court can order an appropriate sanction, which might include not allowing the government to rely on that evidence.
But I guess I'm wondering how that really plays out in a situation in which we're talking about evidence, for example, that goes to the credibility, as you say, happened here. So it's, I think that makes sense in the context of some exculpatory piece of information, and we're trying to sort of suss it out so that we can determine whether or not an adequate substitute can be given, et cetera. But when you're talking about reliance on evidence that goes to something like credibility of a witness, is there really any opportunity to provide an adequate substitute? And if not, how can the court rely on that evidence?
So there is, Judge Jackson, and there's a little bit of awkwardness here because we can't talk about specifics, obviously, and I would just say you can look at the ex parte materials and make a determination for yourself, but I can give sort of general answers and examples. And so, for example, if a piece of evidence that's submitted ex parte because it has some particular sensitivity, if the substance of the information that would be conveyed by that has been conveyed by a different, less sensitive piece of information, then that would be a reason why you wouldn't need to turn it over to the counsel or to the petitioner, because it would be essentially cumulative information-wise. Maybe the petitioner already has that information that goes to credibility from a different, less sensitive piece of information that wouldn't potentially reveal a source or a method of intelligence gathering, something like that. It's hard for me to be more specific, but that's the type of thing that the district court judge considers. And again, Judge Lamberth did not go easy on the government, and nor should he have. He put us through our paces, and we take seriously our obligations when we are detaining someone and depriving them of liberty, of our obligations to give them a fair shake in habeas proceedings, and we believe that was done here. This court for the last 13 years has sort of superintended the district court's habeas proceedings and made sure that these protections are in place without ever having to decide expressly whether the due process clause would provide any extra layer of protection.
I'm sorry, can I just shift you really quickly? I'm afraid I'll lose the floor in a second. To the sort of justiciability concerns that you heard my colleagues raise with Mr. Zoints. I'm wondering whether the government's position is that after the PRB's determination, it is entitled to hold Mr. Al-Hela indefinitely, notwithstanding that decision. Is that the government's legal position?
So I quibble with the word indefinitely. We don't believe his detention is indefinite. We don't know how long it will last because we don't know how long the hostilities will go on. But we do think we can hold him. So he's been cleared. He's been declared eligible for release, but still found to pose a threat. And so we don't think there's any obligation under principles of the law of war. Mr. Al-Hela's counsel has not pointed to any principle of the law of war that would require us to release somebody is held as an enemy combatant when we believe that he still poses a threat. That being
So in the
said,
government's view, is there still a case or controversy in light of this dispute between you and Mr. Zoints on this point?
I think there's still a case or controversy. Of course, the habeas proceeding was about whether he was originally validly declared an enemy combatant, and we agree with the district court's determination that he was. We have now declared him eligible for transfer, and we have no intention of holding him any longer than we would like to. It is a complicated process to find a place where we can transfer him. He is Yemeni. Congress has prohibited us from transferring detainees to Yemen. I think approximately half of the people who are on Guantanamo who have been declared eligible for transfer are Yemeni. And so it's complex, and we are working on it. And I'm not at liberty to sort of reveal the details, but it is a sensitive sort of diplomatic, military, foreign policy operation to try to find a place where we can send these people, a place that will offer the necessary security assurances. And, you know, we can sort of, there's a little bit of a back and forth of trading.
Yes, I
Is
understand the difficulties, but you are affirming that there's still a case or controversy on the detention point, notwithstanding all of that.
I think that's right. I mean, we have the authority to continue to hold him. I don't think this court would really have the authority to just order his release. You know, under precedents like Kiemba and Munaf, you couldn't order him to be released in the United States. And it is really figuring out where we can send him with the necessary security assurances is really sort of a prototypical executive branch type of operation. It involves sensitive military determinations and foreign policy determinations.
But what if he says, which I think is part of what he said, counsel has said in the opening argument, that I'm okay with release subject to security conditions. So at that point, what's the difference? What's the difference between where the executive branch is under its own executive order and what is being requested if conditional release means release subject to conditions that involve security assurances?
Well, before you could order conditional release, Judge Srinivasan, you would have to find that the Constitution requires us to.
No, I understand that, but I'm just asking I'm skipping past that, and I know there's.
Don't do that. Yeah.
I know there's a legal step involved, but I'm just trying to understand as a practical matter.
Yeah.
What's the difference if that's the request of a habeas petitioner is release, but subject to the same security assurances that the government has already said, if in existence would warrant release, then as a practical matter, what's the difference?
So I think as a practical matter, it would be sort of a null order because it's unclear what that would add to the process that's already going on. And so maybe that's your question is there's no practical difference, but the flip side of that is it wouldn't do anything, right? The Article 3 courts can't really superintend the executive branch's sensitive foreign policy and military negotiations with foreign powers.
Which is the null order? I just want to be clear in your sentence.
I'm sorry, I think the judicial order wouldn't have any effect because.
What would the judicial order say in the context of the chief judge's question? That's what I'm not clear about.
Well, I can let the chief judge correct me if I get it wrong because it was his order, but I think the order would say he's ordered to be released subject to security conditions to an appropriate country, something along those lines. Did I get that right, Judge Srinivasan?
Right. So it would be an order of conditional release that mirrors the conditions that the government has already imposed upon itself via the final determination.
Right. So it's just unclear to me what that would do, because I don't think it would be appropriate for a court to try to impose itself into the negotiations that are going on. And so it would just be sort of words on a paper, and I don't think it would have any effect.
What if you were, while you all are going through this process, were to go back and to actually win a habeas petition, have it declared that he was not properly classified as an enemy combatant or is not lawfully held under the law of war? Then it would just be like the Uyghurs looking for a country. It would not be looking for security conditions. Is that correct?
I think that's right, Judge Millett, right? The difficulty, of course, with the Uyghurs was that they had convention against.
No, I understand that. I was trying to say it changes and presumably would take care of at least one part. Now, I don't know whether the bigger part of finding releases is finding a country or finding the security conditions, but I should think eliminating the need for security conditions would at least alleviate the government's burden in this process. Maybe not, as Judge Randolph said, eliminate it entirely, but maybe 2 years rather than 10 and counting.
So if I could clarify my answer, because I think I misunderstood the question. I think the government still has the position that if we lose in a habeas proceeding, we still can require certain security assurances in transferring somebody. I think that's an issue that might have to be
In
litigated.
transferring as to where they go, if a court has said this person was not an enemy combatant, he was just an employee of the government of Yemen. Do you get to do that in domestic habeas? If it's, say, someone that you all said was a leader of a violent gang, and the courts say you're all wrong, habeas granted, you still get to say, well, we need to slow down and figure out when we're going to release them until some gang treaty is negotiated?
No, Judge Millett, we don't need to do that. But of course, habeas, like due process, is a context-specific set of rights. I think our position in other cases has been that we do have the right to insist on certain security measures, even when the writ is granted.
Has any court said you have a right to insist on security measures if the person were determined not to be an enemy combatant and not properly held at all under law of war or otherwise?
I don't believe that's been litigated. I don't, as you know, there's a lot of water under the bridge in these habeas proceedings, and so I could be missing something, but I don't believe that's been litigated or decided by any court. And so we can reserve that question if it were to arise. Again, of course, I think the district court correctly determined that Mr. Al-Hela—
That suggests that there is a difference between the order, an order, that just sort of said, go ahead and do what your executive order says to do. And there is certainly at least an open legal question whether it would be a different habeas order were he to prevail in his habeas proceedings with the assistance of due process.
So I think it would depend on what the question is that Judge Srinivasan skipped over. If the determination is made that maybe he was initially an enemy combatant, but now based on the PRB's determination, he needs to be released, then I think there really wouldn't be a difference. If it's, as you suggest, that he was never appropriately held, then you would have different questions that would come up. So I think that's where the delta is in my answers.
So winning in habeas doesn't accomplish anything for the detainee, because the government takes the position it can still hold you until the hostilities are over as declared by the president?
No, not at all, Judge Rogers. If someone wins in habeas in the sense that the district court or the Court of Appeals finds that he was not correctly declared an enemy combatant, then we could not hold him for the duration of hostilities. What I said is that we have reserved the right to insist on security measures in the country where we transfer somebody in that kind of a situation. But that's
the context of my question.
Okay, but so what we would not assert a right to continue to hold someone for the duration of hostilities in that context.
Of course, just a formalistic difference, though.
Yes, that's what we're trying to understand in this case. What is the realistic difference? The petitioner wins his habeas determination and is ordered released. And the government says we're not going to release him because we can't find a country that would provide what we think nevertheless are necessary security assurances.
Judge Rogers, many people have been released from Guantanamo, including all the people who
I'm trying to focus on where we are now. All right. Let's not talk about the past. I'm talking about what you are saying to this court today.
What I'm saying is that there is no basis for thinking that if someone had the writ granted, we would continue to hold them for quite a long period of time. People have had the writs granted and they are no longer at Guantanamo. That's not what's happening.
Your position is that the government could hold them for a long time, that you can hold them until whatever security assurances the executive branch determines have been satisfied, which they could determine have never been satisfied because someone is still a threat or still dangerous under the understanding of the executive.
That's our
if
position.
that's the case, then what are we ever doing in any of these habeas cases? Maybe.
Well, Judge, that's why I'm pointing to sort of what has already happened in the actual world, which is that where the writ has been granted, people have been transferred. And so I don't think there's any reason to fear that the government would sort of sit on its hands and say, oh, well, gosh, we just can't find someone who will take this person with the right security.
Well, counsel, your whole argument is that this is discretionary, all right, as to whether or not the government can impose security conditions. So winning habeas doesn't necessarily mean that the petitioner won't be held longer, because while there is a country available, the executive has determined that the security conditions which it decided are necessary have not been met. That's all I'm trying to be clear about here. I understand as counsel, you don't want to give too much away, but it's just bizarre here when we're talking about the writ and its purpose as defined repeatedly by the Supreme Court. And now we're hearing the Department of Justice telling us, well, it doesn't really mean what it says. The king could continue to hold him if he thought it was going to be dangerous.
I mean, I just don't think that's quite what we're saying. I think we would hope.
Well, I'm pushing you because I'm trying to understand exactly what the government thinks a court order means.
So we take seriously a court's order that someone should be released. And I think, as I've said a couple of times now, that is evidenced by the fact that the people who have been ordered released have been released, right? And so we are not trying to sort of duck our responsibility in any respect here. I think if you had a situation where the writ was granted and we took a super long time, then the writ could be reopened and the court could step in.
It sounds like there's actually, there is a difference then between having a writ granted and just having the PRB say we shouldn't detain you because Mr. Al-Bahani doesn't have a writ, but he has a PRB order and he's still there. But you said when people get writs, they've been transferred. So it sounds like it does make it.
Well, I believe Mr. Al-Bahani is also Yemeni, and so I'm not aware of what has happened in situations, if there are any, where someone who is Yemeni has had their writ granted. That's an extra layer of complication that Congress has added by preventing us from sending those people home, basically, because of security, national security reasons.
Ms. Harrington, I have just a maybe more legal question as opposed to the practical question. You took the position, as I read your brief at pages 28 to 29, you're saying there's no need to reach a substantive due process claim here because substantive due process doesn't require any more, even if it applied, doesn't require any more than habeas already deals with. And then you talk about the AUMF and how if there's no reason to continue to detain under the AUMF, the government will undertake to release the person subject to appropriate conditions. And this is sort of the back end habeas rather than the front end that we've also been talking about, which is, was he ever properly? Right. So we're talking about a world in which conditions are appropriate, whether by order of the court or not. And then I turn the page and I find that instead of saying the government thinks that he no longer can be lawfully detained under the AUMF, the government doesn't say that. The government says that detention remains lawful for the duration of the conflict. And my question is, where I thought you were going is that you were saying as a statutory matter, it's available to the court to say, no, it's no longer lawful under the AUMF because of the executive's own determination that the critical fact that that is needed for current detention is missing under the executive order and the government's own policy.
So I don't think that's right for a couple of reasons, Judge Pillard. So first, the AUMF, which is then sort of informed by the NDA that came later, authorizes detention for the duration of hostilities. No one has contended in this case, neither Mr. Al-Hela and certainly not the government, that the hostilities have ended. It's a separate question about whether the particular person intends to return to the battlefield. The PRB found that Mr. Al-Hela does not have an intention to return to the battlefield, but found that he still poses a threat to the national security of the United States. And so you would sort of look to principles of law of war and military detention in deciding what is the authority to continue to hold someone in that situation. And there's nothing in those principles that would suggest that you have to, repatriate someone who you've captured in World War II from Germany if you think they continue to pose a threat. Okay.
Right, but under the executive order, and I'm looking at section 2, continued law of war detention is warranted for a detainee subject to the periodic review in section 3 of this order if it's necessary to protect against a significant threat to the security of the United States. Conversely, I take it is not warranted where it is not necessary to protect against a significant threat. And so your position is that's not on its own enforceable, that we would have to recognize a substantive due process right and then use that as a factual basis? Or is it possible that that's enforceable apart from any determination that substantive due process applies here?
So what I would say is that we, based on that determination, have determined not to continue to detain him. And as soon as we can find an appropriate place to transfer him, we will do that. But I don't think that creates a substantive due process right for him to no longer be detained. Substantive
Would
due
create
process.
any legal right? That's really my question. If it's not a substantive due process right, would it be any legal right? And I take it your answer is no.
I think no at this point. I mean, I do think, if in 10 years we're still in the same situation, the court could revisit the question in a new habeas petition or a reopened habeas petition. But I think, I don't want to opine on what the arguments would be in that situation because that's not the situation we have here. It's only been a couple of months. It's a very complicated process. I can say that we are committed to transferring Mr. Al-Hela out of Guantanamo, and people can take me at my word or not, but I mean it. President Biden has said publicly he means to close this detention center, and we are working hard to do that.
Ms. Harrington, I want to go back to fundamentals for just a minute and make sure I understand what you said 45 minutes ago in your first couple sentences. I heard you say that the government believes that detainees at Guantanamo are entitled to robust procedures, right? And did I hear you also say that those procedures are equivalent to those required by due process?
Yes, we think they are at least as protective as—
At least as protective. And that I assume includes the Matthews standard, right? You apply Matthews, correct?
Right.
So in what respect do you think the government and the petitioner disagree in this case?
In terms of what we think is that the process—
your argument now sounds just like his argument. There's a debate about whether we should rule that due process applies in Guantanamo, but which is what he wants. But I hear you saying, and this part of your opening argument was written, I think, you were saying that the procedures that he is entitled to are at least as robust as those required by due process in Matthews v. Eldridge. So I don't any longer understand where the two of you are disagreeing.
So, we disagree on the bottom line, which is whether those procedures were satisfied in this case, whether the procedures that are required, that would be required by the due process clause, were satisfied here.
Well, then what's the government's objection to this court ruling that due process does apply? I understand the avoidance issue and everything. I'm just curious as to why you're so adamant in your brief that we shouldn't reach that if your position is that they, in fact, are already met here and that's all that's required anyway.
So, we agree that it wouldn't make a difference to this case to make that holding, and that's, in our view, a reason not to make it, right? And so we think it's a complicated question. It requires the court to parse the interaction of Boumediene and Eisentrager. It requires the court to figure out whether the kind of functional approach in Boumediene that it applied to the suspension clause should also apply to the due process clause at Guantanamo.
All right, so just let me make sure I understand. So when you said at the beginning that the procedures he got were as robust as he would be under the due process clause, that was case specific. I thought I heard you saying that detainees at Guantanamo are entitled to procedures at least as robust as the due process clause.
That's right, Judge Tatel. I did not, I think it was case specific, and that's obviously the specific question that's teed up for the court, but more generally, the procedures that are in place in the case management order, the amended case management order that governs these habeas proceedings, would satisfy Matthews versus Eldred. And, I think Mr. Zion suggested that you would do a Matthews versus Eldred analysis with respect to maybe each evidentiary question that a district court was faced with, but that's not really generally how Matthews applies. It applies to set up the procedures that govern a type of proceeding. Go ahead.
No, go ahead. I'm sorry.
I don't know that the district courts ever expressly engaged in that analysis in a written opinion when they set up the case management order. But I think if you look at what resulted in the case management order, it is a balancing of the detainee's important interest in being able to challenge the lawfulness of his detention and the government's important interest in protecting sensitive information.
I see. Is that your answer to his hypothetical about the intelligence officer who's now at Langley?
Yeah, I think there is room under the case management order for these evidence-specific back and forth. And you can, if you read the record below, you will see that that is what happened in this case with respect to ex parte material and classified material. Over the long history of the district court proceedings, more and more classified information was shared with declared counsel, in part because circumstances in Yemen changed. And so some things became less sensitive over time. But in part also because the district court pushed and pushed and pushed, and we did everything we could to accommodate, supplying as much information as we could without sacrificing national security.
I'd like to drill down on some specifics here. And in Bismola, the court described the government's position as far as what petitioner's counsel had a right to review, even if they had a clearance. The government had interpreted that they only had clearance to the extent that they have a need to know that classified information. And the government's position was that petitioner's counsel did not have a need to know highly sensitive information pertaining to a highly sensitive source, and information pertaining to anyone other than the detainee. That was what the court said in its opinion. It's my understanding from reading this record that that's still the government's kind of interpretation of what petitioner's counsel needs to know. So even if they have clearance, if the information falls within one of those three categories, the government seeks basically an exception so that they don't have to provide that to petitioner's counsel. Am I right about that or not?
So I'm not sure I can say that those are the only three categories or that those three categories would apply all the time. Basically, the structure that's set out in this court's opinion in Al-Oda governs the ex parte determinations. And one of the factors is whether revealing the information to cleared counsel is necessary to facilitate meaningful review by the detainee. And if it's necessary, then the information has to be shared, or there is a sanction that can be imposed by the district court. And so just to give sort of, again, we can't talk about the record in this case, but I can give you some sort of general examples of things that might fall in those categories where we would think that cleared counsel wouldn't have a need to know. So sometimes intelligence reports have information about a number of unconnected things. That's just the form in which they are created and transmitted. And so we would redact anything that's not related to Mr. Al-Hela or to any sources of information about his case or something, because it's just has nothing to do with the proceedings, and therefore the cleared counsel wouldn't have a need to know. Judge Lamberth, which is a little bit more stringent, he's a little bit more stringent than some other judges. He requires us to justify all of those redactions, even when they're not relevant to the case. And so that's technically ex parte material that is submitted to Judge Lamberth, but it's not material that we are relying on in this case. And it's the type of material that would not be shared with cleared counsel. So I don't know if that's.
But my point is that due process as defined in Hamdi, the core question was really notice and a fair opportunity to kind of respond to the factual allegations of the government.
Right.
Hamdi didn't pass upon whether it would comport with procedural due process to allow the fact finder to review information that went to reliability of government sources or the probative value of exculpatory material from the government ex parte, right?
Yeah. Well, what I can say is,
so that's an open question for us, right?
Well, but this court has engaged with this question before in cases like Al-Oda. And what I can say is that those same touchstones govern district courts' decisions about ex parte evidence. Is it necessary? Is sharing it necessary to facilitate meaningful review? Is it necessary? And that would include, is it necessary to allow the detainee to rebut the factual basis for his detention?
But here we have information that went to reliability of hearsay declarants that was submitted to the court ex parte.
Right.
Right? That's the core question here. Is in these cases where the whole case boils down to hearsay, is the reliability of those declarants. And so on a key critical issue that goes to the merits, that goes to the issue about that we're worried about the risk of an erroneous determination, that some determinations on that key issue were made as after an ex parte review. where by definition, there was not an adversarial, presentation with respect to that information. And again, adversarial presentation goes to the core of reliability and due process. So why isn't that problematic?
So Judge Wilkins, I will say, that is a dynamic that is always in play when you have a case that involves sensitive national security information that can't be shared with the other side, and courts have, sort of managed to deal with it, and it's a high standard. And of course, the district court himself, the district court judge himself, is there to be able to evaluate the evidence, and you can look at the evidence and say what you think. It's a little bit hard to engage with you specifically. I'm not trying to dodge the question because we can't talk about the specifics of this case. But again, some ex parte evidence that's included that the judge can see is cumulative information-wise of other evidence that cleared counsel has seen or that has been shown in some cases. I'm just speaking sort of in general terms, not necessarily about anything that happened in this case, although I think this type of thing came up with respect to some of the ex parte evidence in this case. And so in that case, a district court can appropriately make a determination that it's, you don't need to undertake the national security risk by sharing that information when it wouldn't provide any additional information to the detainee's cleared counsel. I'm not sure what else I can say in this open setting that would make you feel better about the ex parte, and I mean that in a pejorative way, that would sort of assuage your concerns, your legitimate concerns about what's happened with the ex parte material in this case.
Well, what you can do is help me understand the orders that you talk about in your brief at pages like 8 to 9 or 7 to 9, where you're talking about the what happens with classified information and how it's disclosed and not. You point out that in the case management order, paragraph 1F, that the government can move for an exception to disclose to petitioner's counsel, and that's what we're talking about. And that the court has the authority to overrule the exception and order disclosure. Just so that we're clear, you're agreeing that the court can order that, but of course, if the government doesn't want to abide by that order, the court can't kind of force the government to turn it over. Then the court can just determine what sanction or whether it's going to say the government just can't rely on that piece of evidence, right?
Absolutely, yes.
But that order, that case management order, doesn't say what standard the court should use in determining whether the government's exception should be sustained, right?
This court has said in Al-Oda what standard to use. The information, the information has to be relevant and material. Access has to be, this is the requisites to order the release of the information. Access has to be necessary to facilitate meaningful review, and alternatives cannot suffice to satisfy that meaningful review standard. And so oftentimes there will be a piece of information, say the identity of a source that is sensitive. This is just, again, hypothetical, and that the judge can see in an ex parte way, but that we wouldn't want to reveal to the cleared counsel or to the detainee. And so you can put in a substitute, which is like, John Doe, right? You put in a pseudonym, source Z, whatever. And that is a substitute, a less sensitive substitute for that information, that piece of information. And so the judge will know who the source is and then may say, well, okay, we can have that substitute, but then you need to provide additional information to let the detainee and his counsel understand where else John Doe appears in the evidence and how those bits of information interact. And so, it is a complex back and forth. It's the touchstone is, does the detainee have a meaningful opportunity to challenge the basis for his detention? We embrace that as the appropriate standard, and we do what we can to make sure that that's what happens. We take.
I feel like I have the same possible concerns that Judge Wilkins has, and I hope that I can articulate them in a question. I'm worried about whether there's a delta between what the case management order says and what you say has been required by the suspension clause with respect to the procedures, and the way in which Judge Lamberth may have vigorously applied that in this case. Is there a delta? In other words, you sort of continue to say that Judge Lamberth did a very rigorous job, and so we don't need to determine whether the due process clause requires the kind of application of these procedures in the way that he did it. But you also say that there's no difference between the suspension clause and the due process clause. So I'm a little concerned that a future judge is not going to do as vigorous a job as Judge Lamberth, and that therefore there might be a gap between what the suspension clause requires and what the due process clause requires.
Understood. Thank you for that clarification. So I'll say that just my understanding from my team who has litigated many of these cases is that different judges have slightly different standards. I think it's Judge Sullivan will not consider any ex parte evidence, right? And so different judges have applied additional layers of protection onto the case management order, but I do think the case management order itself, it provides robust protections, possibly more than it would be required under the suspension clause or the due process clause. To be specific, I think the one way in which Judge Lamberth requires extra protection, this is my understanding, is that when we submit documents that are exhibits to the factual return, he requires us to justify redactions that go to what I was describing earlier, bits of the document that talk about things that are completely unrelated to this matter. We are required, this is what I've been told, to show those to Judge Lamberth and explain why they're being redacted. And the explanation is it has nothing to do with this case. It's about something totally different and just happens to be in the same intelligence report. I think that other judges under the case management order don't require those particular types of redactions to be justified. So I think that's the only difference. And I don't think that makes what the other judges are doing unconstitutional under the suspension clause or the due process clause if it applied. I think either way, there are robust procedures in place, robust protections, and there is always the opportunity for the back and forth. There's the opportunity for cleared counsel to seek additional information, to challenge redactions. There was litigation in this case about additional discovery, and then Mr. Al-Hela decided to stop, and the case went to determination.
Harrington, if I can ask you some questions about the constitutional avoidance point that the government has made. I guess I'll be honest, I don't see how we manage to avoid deciding a constitutional question in this case. I mean, Mr. Al-Hela has argued quite clearly that he believes the due process clause entitles him to more protections, more procedural and substantive protections than were afforded to him in the proceedings below. And so if we are to reject that argument, we have to decide, it seems to me, one of two things. We have to decide that the due process clause does not apply in Guantanamo Bay, or we have to decide that the due process protections are, as the government has suggested, entirely coextensive with the suspension clause. And it seems to me both of those are quite substantial constitutional decisions. So I guess I'm not sure,
Right.
While we of course try to avoid constitutional questions, and you've given a lot of practical reasons why perhaps Mr. Al-Hela has been afforded sufficient process. I'm not sure how that answers his legal claim that due process has not been satisfied here.
So, Judge Roy, you're absolutely correct that there is no way to avoid making constitutional determinations in this case. Mr. Al-Hela's claims are constitutional. And so it's not constitutional avoidance in that traditional sense of just avoiding deciding constitutional questions. I guess our main submission is that the court should go small instead of going big in making constitutional holdings. And if you look at what is the constitutional question that's presented here, it's would the due process clause require additional protections in addition to what the suspension clause is already providing if it applied? And we think the answer is no, and that's a relatively small constitutional holding, much smaller than saying, for example, the due process clause applies at Guantanamo or the due process clause does not apply at Guantanamo. I think either of those holdings would implicate an array of contexts and types of claims that are not presented here and haven't been addressed here.
And so, Ms. Harrington, how is it smaller though? I guess I don't understand how it is smaller because I'm not aware. Judge Griffith didn't cite in his concurrence, and I'm not sure the government has cited any case saying that the standards under the due process clause and the suspension clause are equivalent.
Right. So, both are
so that is quite a substantial holding.
And so let me be clear. Thank you for that question, Judge Rao. We're not urging the court to say that in all contexts, the suspension clause and the due process clause provide the same protection. Whatever the court holds, we think it should make clear that it is only deciding what constitutional protections are provided in habeas proceedings for Guantanamo Bay detainees. Okay, because there's a different balancing of rights that would be necessary in a different context or with respect to different types of claims. And so we think in this context, where actually what's required in habeas is quite robust, given the context of having review of an executive determination. As I said, it's de novo review. There's all sorts of obligations on the government to turn over inculpatory and exculpatory evidence in ways that wouldn't necessarily apply in what one would think of as a more traditional habeas context. And so in this context where you have these robust habeas protections, we think the due process clause wouldn't apply any greater protection. And it's in part because the purpose of both sort of layers of protection is exactly the same: to provide the detainee with a meaningful opportunity to challenge the basis of his detention, including by challenging the factual basis and presenting exculpatory evidence. That's the same, those are the same purposes. And so when they're applied in this context, they would lead to the same result.
There's the Supreme Court held that?
As the Supreme Court held that they would apply in the same way in this
No,
context.
they're equivalent.
The Supreme Court has not held that in this context they're equivalent,
No,
but
it's
again,
an open question. I mean, Judge Rao is completely correct, isn't she?
Exactly. I do think there's no way to avoid making some constitutional holdings in this case. But I think that the signals in Boumediene were that the suspension clause requires procedures in habeas that could be more robust than what the due process clause requires. Because again, Justice Kennedy assumed, again, without citing, you're right about that, Judge Rogers, that the CSRT processes satisfied due process, but that quite a bit more was required through the suspension clause in habeas proceedings.
Go ahead, Judge Rao, sorry.
Oh, sorry. So, I mean, the government's position is that the due process clause provides the same or possibly less than, protections than the suspension clause.
I mean, we think
that's quite I'm not sure how that is a small constitutional holding. I mean, if we think due process is an important constitutional right, which I think I'm sure all the judges of this court believe, to suggest that, we can just sort of say, well, this is good enough, it's the same as this other provisions that we get under the suspension clause. I'm not sure that gives sufficient attention to the importance of the due process right.
Judge Rao, we absolutely agree that the due process clause is important, the rights are important, and I just want to append onto everything you say in this context, in habeas proceedings brought by Guantanamo detainees, because we are not making any representations about what the overlap would be between suspension clause.
So due process clause is contextual, but once we make a due process holding in one context, it of course has spillover effects for other contexts. I mean, the government's brief is rife with, this is like a one-time only thing. This is just for these detainees in this place. But that's not the way law works. When we do a due process balancing in one context, it will invariably have some implications for other contexts. And we will have another data point for how do we analogize the due process rights in this particular case to other cases. So it is not a small holding for us to say that the due process clause means this in this context.
That's true. I just mean it's smaller than saying the due process clause applies at Guantanamo or it doesn't apply at Guantanamo writ large in a way that might implicate other types of claims and other contexts that are not implicated in this case. And so I don't mean to suggest it's not a consequential holding, that it's not a constitutional holding, it is, but there are even greater constitutional holdings, as you know, having written the panel opinion, that would have broader application that the court could.
Well, maybe it's only smaller because the government's position is that they just have to take seriously our holding, but not follow it. So maybe it doesn't really matter.
I'm not sure I understand what the question is, but we would.
Well, Ms. Harrington, you said earlier that if we were to issue a writ, you would take it seriously. You didn't say that the executive branch would then release someone. So maybe it doesn't make any difference.
I didn't mean to suggest that we would just ignore what the court has says, not at all. We're very respectful of our Article 3 friends. What I meant to suggest is that it would not require us to do anything additional to what we are already doing, which is undertaking every effort to find somewhere to transfer Mr. Al-Hela. I don't think, and I haven't heard any judge on this court suggest today, that the court could sort of insert itself into the foreign policy, diplomatic, military negotiations that are going on to try to effectuate a transfer. And so in order to find a place to send him, I just meant it wouldn't, as a practical matter, change facts on the ground because we are already.
The way you've defined the universe of situations in which the Bermudian suspension clause rubric is coextensive with due process is habeas proceedings involving detainees at Guantanamo. And I just want to carve out commission proceedings, because as I understand it, if there were military commission proceedings involving detainees at Guantanamo, the suspension clause wouldn't give those kinds of protections in terms of what happens during the course of a commission proceeding, right? So,
right. And so part of the point of my suggestion is that you shouldn't make a holding that could be viewed as governing those proceedings, because there's a whole different set of balancing that goes on in a military criminal tribunal.
Well, there's a trial that began or restarted on September 7th of this year. You're familiar with that, right?
Yes, sir.
It's Khalid Sheikh Mohammed's trial. And if the due process clause, if this court were to hold that the due process clause applies in Guantanamo, there is absolutely no, and Judge Rao is correct about this, there's absolutely no way to distinguish that trial from a habeas proceeding. As a matter of fact, it's more serious because the government is seeking his execution.
So, Judge Randolph, absolutely, and you're underscoring part of the reason why we are urging caution here. We would urge the court not to hold that the due process clause does or doesn't apply at Guantanamo.
Let me just follow up. See if this sounds familiar to you. We reject the claim that aliens are entitled to Fifth Amendment rights outside the sovereign territory of the United States. Is that a familiar statement to you?
I believe you're quoting from Eisentrager.
No.
Oh, from our panel brief, perhaps?
It's from Verdugo, the Supreme Court. That's the Supreme Court. You say it's complicated. That doesn't, what's complicated about that statement?
What's complicated is reconciling those statements with what the court said in Boumediene.
That's a holding. Boumediene did not hold that the due process clause does apply or doesn't apply. It said nothing about that and was explicit about it. So here's the question I have. That's Verdugo. The government relied on Verdugo and Eisentrager and other Supreme Court cases last December when the brief was filed. Now, besides the change in administration, why is the situation now any different than it was last December?
Judge Randolph, I'll be honest, is the change in administration. The grant of rehearing en banc gave us an opportunity to rethink our position, and it gave us an opportunity to ask ourselves, what would be different if the due process clause applied here? And we think nothing would be different in terms of the protections that are afforded. And so therefore we reverted to earlier positions. And I'll just say before the panel, our first position was that the court should avoid deciding the due process question. And it's true that our backup position was that if it did, it should decide it doesn't apply. But we decided
the backup position is that the due process clause does not apply in Guantanamo?
That is not our position now. That was our position before the panel.
If it's not your position now, and this court holds that the due process clause does apply, you're not in a position to file a petition for a writ of certiorari, are you?
I don't want to, I guess it would depend on what the court said. I don't want to disclaim any circumstance in which we could do that, but we are not.
Well, you can't do it because you're not arguing the point that gets decided.
Well, I mean, it depends how broadly the court rules. Again, we are not taking a position on whether the due process clause does or doesn't apply because we think it wouldn't make any difference and therefore the court shouldn't decide it. But whatever the court decides with respect to the due process issues, we urge it to limit its holding to habeas proceedings brought by Guantanamo detainees and not to rule more broadly on sort of a territorial basis or something that sounds like a territorial basis. Because I think what we learned from Boumediene is that these sort of formalist views of the extraterritorial reach of constitutional provisions isn't how the court is viewing those questions anymore. And so we know, at least for the suspension clause, that Guantanamo is different from many other parts of the world. We don't know how the court will view, if it ever has an opportunity to decide, whether the due process clause, should be viewed in the same way as the suspension clause. Those are hard questions. Reasonable minds can disagree. They're complicated questions. We think the court should avoid answering them if it can. And we think
I have your point.
But Ms. Harrington, your argument for constitutional avoidance requires a constitutional determination. I mean, your argument that we should avoid the constitutional question is because the standards are the same.
No, true. I conceded earlier, there's no way to avoid making constitutional rulings in this case. His claims are constitutional, right? Even if you sort of revert to the old way of saying, well, we're not going to decide if it applies because if it applies, you'll be satisfied. Those are constitutional holdings, right? About how those protections would apply in particular cases.
And you're not asking us to make that. So Judge Rao outlined two possible rulings, which she said both of which implicate the Constitution, one, due process doesn't apply, or the suspension clause gets you as much as due process and therefore don't reach the applicability of the due process clause. And I guess the third way, maybe you're referring to this as the old way, is to say, assuming it would apply, nothing that happened in this particular case would implicate any potential delta between due process and the suspension clause, and therefore we're no harm, no foul. We're not going to reach any constitutional question except in this kind of hypothetical way. You're not asking us to do that here.
So we would be fine, of course, with the court doing that. I guess our assumption has been, because the court is sitting en banc, it would want to do a little bit more than that, more than the sort of the most case-specific result it could reach. But certainly we wouldn't resist that result. And we think that's an even more sort of small c conservative way to approach these difficult questions.
On the middle one, the due process, at least for habeas petitioners at Guantanamo, the suspension clause affords them as much process. That's not what the panel thought, and that was part of their sense of the propriety of reaching your first framing. Due process clause doesn't apply. What's the strongest logic that I know you've been over this ground a lot, but just that there isn't a case on that. And is it that both the suspension clause and the due process clause have roots in the common law, or going forward, to the extent that we do have a role as the en banc court to give guidance to the district courts who are really in the trenches here, could we rule that, as you've said, rather than just saying, oh, the case management order is full of robust protections, but actually that in this context, the suspension clause gives as much, if not more, than the due process clause? What's the source or logic or thinking for that?
I mean, I don't mean this as a cop-out, it's all context specific, right? And so as I've said, the protections that are provided by habeas in this context are quite a bit more robust than might be provided in a different sort of context, because, and the court sort of went into this in Bumedia, and the court is reviewing an executive determination detention rather than another court's determination. So you haven't had a neutral decision maker. That's why it's de novo review. I mean, de novo review in a habeas context is pretty unusual, to say the least. And so, I think what you could say is the suspension clause requires robust protections that are meant to ensure a meaningful opportunity to review. That's the same thing that the due process clause would require. We think it wouldn't require anything more in this case. And you could say to the district courts, if you wanted to, we think the case management order adequately reflects or appropriately reflects what the Constitution would require in this case, and you should adhere to it or continue to adhere to it. I'm not sure that's necessary, because I don't know of any judges that are trying to depart from the case management order. But if you're asking sort of what you could say to give direction, I think that's one thing you could say.
Hey, let me make sure my colleagues don't have additional questions for you.
I have a question. Sure. Isn't it the case that the government has taken the position that there is some information about sources of hearsay statements that's so sensitive that they're not even providing it to the court, and they have redacted it even for the district court for its in-camera review? And didn't that happen in this case?
I believe there may have been some instances of that, yes. But
why isn't that a procedural due process problem, in the sense that we have a situation where not only there was no adversarial presentation, but there was information that could be relevant to reliability that the court didn't even see?
So what I would say is that before we could do that, we would have to convince the district court that it was an appropriate thing for us to do. And part of that inquiry is whether it would be necessary for the other side to see it to provide a meaningful opportunity to review. And obviously I can't talk about specifics, but where that has happened, it's because we have convinced the district court that that was an appropriate thing to do. And so I think, that's a safeguard. And you can look at the record.
And when you convinced the district court of that, you did that in an ex parte proceeding where the petitioner's counsel couldn't rebut all of your arguments and justifications, right?
I mean, that's right. And that's true of any proceeding that involves classified information or sensitive national security information. There is always, a little bit of a give and take where you have to balance the detainee's interests with the government's compelling interest in protecting national security and sources and methods that are highly sensitive. And so I think, the district courts who oversee these cases are quite skilled at making these determinations. They do not make it easy on the government, nor should they. And so it's hard.
With that same position, there's stuff we just can't even disclose to the district court applied to exculpatory information.
I don't know the answer to that, Judge Millett, and I apologize for that.
Isn't that pretty important?
That would be important, but
Would a district court ever rationally say that it's okay, we don't need to know about it with respect to exculpatory information?
Probably not. I mean, I think.
Okay, but then in under our Constitution, sort of in the criminal context, Brady, Giglio are equivalent. The line between reliability and exculpation is, if it's there at all, it's hair thin. And so to the extent these reliability issues bear on exculpation, for example, your John Doe, Jane Doe, that's all you can reveal. If it turns out, if you revealed it, it was the person who was the sworn enemy of Detainee X. And when they were together in Pick Your Country, they had some tiff over a business dealing or a romantic relationship. And that person swore, I'm going to get you, I'm going to destroy you. But that's never disclosed because that would disclose the identity of the source. How can this process be remotely fair under your view of the suspension, what the suspension clause allows?
Excuse me, when we have evidence like that we can't reveal to cleared counsel or the petitioner, we show it to the judge.
I'm talking about, say you say we can't show that to you, district court either.
So I'm not aware of any such evidence in this case, and so it's a little bit hard to talk about.
We're not, as you said, we're taking this on bank, and right. And so, if you're not sure whether there's ever been exculpatory evidence that hasn't even been shown to a district court judge, and if the line between exculpation and reliability is quite difficult to police, and so it's going to be very hard even for a district court if you say it's not exculpatory information, it's just reliability information that we can't show to you, district court judge, and we can't show to you because, and you give your national security explanation. How's a district court supposed to know that this is actually the linchpin?
We don't draw a distinction between sort of reliability information and exculpatory information. Reliability information is a type of exculpatory information, right? So I take that point, and there's a thumb on the scale, obviously, or an entire body on the scale of releasing that information, and we do that. But
you said there's times you don't even show that to the district court judge. That's what you said to Judge Wilkins. There's reliability information, which you just said is equivalent to is not equivalent to is exculpatory information, and we're not showing it to anybody.
I didn't, or at least I didn't intend to characterize the type of information that wouldn't be shown to a judge, but it would be something like source identifying or method identifying. But again, we have to give
source identifying. It can be hugely relevant to reliability and exculpation.
Okay, but we have to convince the judge that it's okay to do that, and oftentimes it'll be because we've provided substitute information, because it's cumulative, something like that. I hear what you're saying, and it's a legitimate concern, and it's a little bit hard for me to meet you where you are without being able to talk about specifics. But I would just say the judge just doesn't take.
But you couldn't even talk to me about with specifics because you said, if you can't show it to the district court judge, you couldn't talk to us about it either, right? There's just this whole secret evidence thing that might very well be exculpatory that no one gets to see, and yet we're supposed to decide. Decades-long detention decisions, and that's all okay under the suspension clause in your view, and you don't think, and we're supposed to conclude that due process wouldn't require at least showing it to the district court judge. That's your perspective.
No, I think the premise of your question is that ex parte information that isn't even shared with the judge will play a larger role than it has ever played. And if we were in a closed setting, I couldn't show you the things that we wouldn't show to the district court judge, but I could explain to you what our reasons were for keeping them back. and they might include reasons such as it's cumulative. We've provided a less, we've provided a substitution such as an alias, or something like that. And so I'm not trying to dodge your question, but it's hard for me to be more specific. You have access to the ex parte record, and so you'll be able to sort of maybe fill in the details.
I'm talking about the legal principle. I'm not talking about the record in this case, the legal principle that you want us, when you say the suspension clause gets you all the way there. If we thought due process might not allow you to hide even from the district court judge exculpatory information, then that would be a difference.
Yeah, but I don't think you could make that determination on that general level. I think what you would say is the due process clause requires a balancing of the detainee's interest with the government's interest, and making sure that anything that's held back is not necessary to provide a meaningful opportunity for meaningful review, and that's the same sort of balancing that happens under the suspension clause. And so I don't think there's anything in the nature of those two constitutional rights as they apply in this context that would lead anyone to believe that they would lead to different results with respect to this issue or any other issue about how these proceedings are conducted.
May I ask my colleagues if they have additional questions for you, Ms. Harrington?
No.
Thank you for your argument.
Thank you.
Mr. Zients, we'll start by giving you 3 minutes for rebuttal.
Thank you, Your Honor. I appreciate that. A few points. One, I do want to clarify exactly what we're asking for. Mr. Hela has all along asked for an order of release, period, full stop. And I think what's happened after we filed our opening brief is there was a PRB determination. The PRB determination concluded that continued detention is not necessary. It had the caveat that the government felt that there were security interest assurances that should still be in place. So I think when I said that we'd be happy with an order of conditional release, what I should have said is at a minimum, there should be an order of conditional release. There can't possibly be a basis for the government to continue detaining someone when it's decided that is not necessary for security, if all of the government's own conditions have been met. But certainly to Judge Millett's point, if there were a determination, and we think there should be a determination that Mr. Al-Hela was never part of or a substantial supporter of Al-Qaeda or associated forces, he should just be entitled to release. Our argument, even on substantive due process, is that the periodic review board decision has simplified things a bit, but we think the government is wrong that there is any remaining security threat at all. So just to be clear about our position, it's really at a minimum there should be that conditional release. We are still asking for release. The second point I wanted to make. Oh, sorry, I see Judge Millett. You may be asking me a question, but you're on mute.
Sorry. Thank you. Famous Zoom line. You don't get to ask this court for that, right? What we'd ask for is a determination on your due process question, and then a remand, and then a whole new proceeding in the district court, and then if there's an end result of that, right? That's what we're talking about here.
Right, Your Honor, and I think we go back to the fundamental point of the interest that Mr. Al-Hela has in having his liberty restored as soon as possible after 19 years of detention. So yes, I think we're asking this court for an order that Mr. Al-Hela has due process rights that have been violated. We think on this record the court can remand with instructions to grant the writ and to order his release, at least with the conditions that the government has said would make him no longer a necessity to detain. Whether other things would still be open on a remand, I think is a different question.
Order his release where?
Your Honor, I think that it would just be to order his release from the government, which has told us that it takes court orders of release seriously. It would be on the government to find a place for him to go. It is, the government has imposed its own restrictions. It is said that Congress has passed a law regarding Yemen. Mr. Al-Hela has, recently, Mr. Al-Hela's counsel informed the State Department that Mr. Al-Hela's counsel was told by family members of Mr. Al-Hela that he approached they approached the foreign ministries of Oman and Qatar, which would be willing to take Mr. Al-Hela. Mr. Al-Hela's counsel told the State Department, we have no idea what the government is doing with that information, if it's looking into it or not. This sort of goes to why there should be a court order here. And I think that segues into the second point that I wanted to make, which is the government tells us they take court orders seriously. What we know, what the government has said today is whenever there's been a court order to release someone, they find a way to do it. They find a way to release it. The other thing we know is that when someone is cleared by the PRB or a process like the PRB, nothing like that is assured. We know that Mr. Al-Bahani has been in detention for 10 years. Ms. Harrington says that maybe Mr. Al-Hela's constitutional claim would be different if after he's been cleared, he's still in detention for 10 years. He's been in detention for 19 years, and we really don't think we should have to wait. He should have to wait 10 more years, and then maybe somehow he has a constitutional claim that ripens. I had two really short points, Chief Judge Srinivasan, although I do see I'm over the 3 minutes.
You can go ahead and make them quickly. Thank you.
Thank you. I appreciate that. The one point I would make on procedural due process, Ms. Harrington said that their view is that the suspension clause is at least as robust as due process. The only reason the government is able to take that position is because they've defined how robust due process is to such a bare minimum that looks nothing like what is recognizable as due process. And I don't take issue at all with Ms. Harrington's suggestion that the Matthews v. Eldridge balancing analysis should be done holistically rather than piece by piece. I think this case shows you why this process here is so flawed. As I think Judge Wilkins was alluding to, this case is all about reliability and credibility. It is not about someone was picked up at Tora Bora carrying an AK-47. This is all about reliability. This is all about credibility, and the hearsay issues, the ex parte issues, they all go to that. Very final sentence, I really haven't had a chance to say anything about the constitutional question of, does the due process clause apply? I just very quickly would point out, I believe Ms. Harrington said that if the court answers that question, it would have to grapple with the relationship between Boumediene and Eisentrager. Our view is the relationship is dictated by Boumediene. It interprets Eisentrager. It tells us what Eisentrager holds, that Eisentrager is consistent with the functional approach to the application of the Constitution that Boumediene requires at Guantanamo Bay.
What about Verdugo?
Verdugo, Your Honor, I think
you never even cited Verdugo in your brief, did you?
Your Honor, I'm not sure. You may be right that we didn't cite Verdugo in our brief. There's a case about the Fourth Amendment. There's a statement about the applicability of the Fifth Amendment, and even if we were to accept the view of Eisentrager, the sort of formalistic view that I think Boumediene rejected. If you accept the view that under Eisentrager and under that sentence in Verdugo, the due process clause does not apply outside of the territory of the United States, that doesn't answer the question in this case, which is what, for constitutional purposes, is the territory of the United States. And what Boumediene holds is that Guantanamo Bay is de facto the sovereign territory of the United States, and the line of the insular cases impractical and anomalous. What then Judge Kavanaugh said in his opinion in Al-Balul, that for constitutional purposes, Guantanamo Bay is akin to Puerto Rico. So I think,
and there's another Supreme Court case saying that whether a particular area is de facto or de jure sovereign territory of the United States is not for the courts to decide. It's a political question.
Your Honor, what Boumediene says is that it is not for the courts to decide, to contradict the government's position that something is or is not, under the de jure sovereignty of the United States. The Boumediene certainly does not disclaim the ability to decide that de facto, and for purposes of the application of the Constitution, something is under such complete and indefinite control of the United States.
Yeah, I have your argument. Thank you.
Okay, thank you, Your Honor.
Mr. Zions, if we read Boumediene as you suggest to basically hold that Guantanamo Bay is Florida or Virginia, are there other clauses of the Bill of Rights that would apply at Guantanamo Bay? Free speech, free exercise?
Your Honor, to be clear, we're not reading Boumediene to say that Guantanamo Bay is like Florida or Virginia. The closest, I think, then Judge Kavanaugh, the analogy he drew, it's closest to Puerto Rico. And what Boumediene relies on is the line of the insular cases, and it's case by case. It is, based on the impracticable and anomalous standard. And what we know from that standard, from the insular cases, what the Supreme Court has said, the very core that is always run in territories like this is the right to be free from deprivation of liberty without due process of law. I can give an example of something that might not apply, which is the warrant clause of the Fourth Amendment, where that may be impractical because there wouldn't be a magistrate to go to on Guantanamo Bay. And otherwise, I think it would just be it would be case by case. Your Honor, I would just close by noting that Ms. Harrington said at one point that Mr. Al-Hela's detention is not indefinite. We just don't know how long it will last. Respectfully, I think that is indefinite detention. Mr. Al-Hela has been in detention for 19 years. We don't know. The government won't tell us how long it will continue, and we would respectfully urge the court to reverse and instruct the district court to grant the writ.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
This honorable court is now adjourned until Monday, October 4th at 9:30 a.m.